I've titled this Things That Your Estate Planning Lawyer Wishes Everyone Knew, and that's a little bit self-serving. People come in to sit down with me in various states of preparedness. Some people have everything in order and they know exactly where everything is and how it's titled and where they want it to go. And it's super quick and you just kind of walk through it and you know exactly what to do for these people. More often than not though, people don't really have a good grasp on where everything is, what is in what place, and what they want to do with it. So I want to prepare you for that initial consultation with the things that I wish you knew before you came to talk with me. So first off, one of the big concepts people often mistake is financial planning and estate planning. There are some similarities, but they're really very different things. Financial planning is where you meet with someone who's well-versed in investments and how to save money and how to essentially create a plan to help you grow assets and manage them so that you're set up for retirement. It's with you in mind, it's with your lifetime in mind, and the goal is typically to make sure that you're comfortable, that you have enough, and that you can kind of live the way you want to for the rest of your life. Legal estate planning is not that. It doesn't deal so much with how to invest, how to save, or how you plan to spend your retirement. It's more about what happens at the end of all of this. So it's more future focused on what happens at the end of your life and beyond. It's where you sit down with an attorney, not a financial advisor. It's creating a plan that's more focused on your beneficiaries than it is on you. A bit on you, but the end goal is to kind of streamline everything and make things as easy as possible on the people you're leaving behind. It's not, like I said, it's not just financial, it's medical and financial and legal. So it's all these things wrapped up into one. And an estate planning attorney can kind of walk you through every single one of those issues, help you understand your options, and prepare all the documentation to set things up so it's legal and binding and won't be questioned. The healthcare proxy. This is not a power of attorney. It's a different thing. This is specific to medical decisions. It's a legal document that you prepare and you execute in a very formal way in front of witnesses. It's a way to appoint a person or multiple people in succession, if the first person can't do it, to step up and make a medical decision that might need to be made if you can't do it yourself. Say you're unconscious. Say you've lost the mental capability to understand decisions like this, and it's clear that you're incapable of doing so. The healthcare proxy is the workaround for that. So you'll sit down with an estate planning attorney and kind of walk through that attorney's form. This isn't something that's produced by the estate. It's kind of however the attorney wants to put it together. It's a way to require medical professionals, meaning doctors, nurses, anybody who's presented with a situation where a decision needs to be made about what to do in a medical way with you. What types of care you're supposed to get, whether measures are to be taken to prolong your life, things like that. Heavy questions. It directs that person to a single individual at any given point who is authorized to make that decision. Most of the time, people will appoint one of their children or a close friend or relative, a sibling, even a parent sometimes, if your parents are around and capable. This person then gets the final say. Now, they're supposed to act in accordance with your wishes, but they get to tell the doctor, yes, go ahead and do that, or no, don't do that, do this. The power of attorney. Kind of the same idea, but for a very different purpose. The power of attorney specifically does not deal with any healthcare questions. It deals with pretty much everything else. So banking, paying bills, dealing with your property, dealing with your investments. It can cover all these things. It can cover some of these things and not others. But the idea is kind of the same. You appoint a person, or in this case, you can appoint multiple people to act together or separately as you choose. You go through this form that is prepared, in basic form by the state, but adapted to your needs. And you can select or omit certain levels of authority. And at the end of it, you sign in front of two witnesses. You have it notarized. And then your appointed agents will sign an authorization page. And once that's all done, you've essentially appointed a person or multiple people to step into your shoes and do whatever needs to be done outside of medical decisions for you. Or if you set limits, then for a limited purpose. It's you can tailor it to your needs. The point is that you've got somebody who's capable of stepping up when you can't. So your rent gets paid, for example. Your bills get paid. If your house needs to be sold, it's sold. They can handle whatever needs to be done using this power of attorney that, when they need to do it. The last entry I have here is advanced directives. And this is kind of a general catch-all category for the healthcare proxy, but also other things that you're probably familiar with. If you've been to a doctor in the last 5 years, you've probably heard of something called a DNR. And if you've been on the internet ever, you've probably heard of something called a living will. Fewer people have heard of a MOLST. It stands for Medical Order for Life-Sustaining Treatment. Usually those are only kind of in play when somebody is terminally ill, or there's a reasonable chance that they might not live beyond the next 6 months. So fewer people are familiar with those, but those are something you complete with your doctor. Your DNR, which stands for Do Not Resuscitate, and a MOLST. Those are kind of further down the road considerations, not something you cover with an estate planning attorney, but it's part of this whole picture. So I feel like I should mention it. The living will, if you want to, is where you can spell out exactly what decisions you want to be made. So if, for example, you don't want to be resuscitated if your heart stops or something, or if you find yourself in a terminally ill situation and the doctor's trying to determine whether or not to give you artificial nutrition or pain relief, or a handful of other common medical questions that are presented when someone is nearing the end of their life. The living will is an opportunity for you to spell out expressly exactly how you want it to go, what you do not and what you do not want. Ideally, you've selected someone who's decisive, and you've had a conversation with this person about what you want to happen in a given situation, and they will act according to your wishes. But in the moment, it's hard. You're getting pressure from maybe your big sister who thinks something else should be done. In that situation, sometimes the appointed agent under the healthcare proxy can benefit from having the living will, which is a signed statement from you saying, I do not want this. And that can usually resolve any disputes. Trusts. This is usually high on the list of things that people want to talk about when they first come and sit down with me. Do I need a trust? The short answer is probably not. Trusts can be fantastic. They can give great flexibility. They can give you great control, to set things up the way exactly that you want them to be for an extended period of time. There are living trusts, testamentary trusts. Those are two different things. One is set up during your lifetime. You create it while you're alive, and it persists for as long as you want it to. The testamentary trust is something that arises from the terms of your will. It's created when you pass away. So, there are positives and negatives to that too. Revocable trusts versus irrevocable trusts. Here's where we start to get a little tricky with the terminology. Revocable means you can change it when you want to, as long as you're still alive and of sound mind. You can change it. You can restructure it. You can revoke it entirely. You can do away with it. Pull it totally out of existence. Irrevocable trusts are not so flexible. And you might want to create one of those for a handful of very specific reasons. But more often than not, they're too burdensome, and it's just not worth it for most people. The main reasons people want to establish a trust during their lifetime. Avoiding probate. So probate is this boogeyman that everybody seems to be afraid of, and then when you ask them, they can't really say why. It can be long, it can cost money sometimes, but for most people, probate works just fine. Another reason people want to establish a trust during their lifetime is to reduce estate taxes, potentially. So this would be an example of an irrevocable trust. If you think that your total assets might exceed the tax exemption threshold in the state of New York, which currently is $6.58 million, then you might want to consider setting up a trust to avoid or reduce your estate tax burden. Medicaid planning is the third main reason that people might want to establish a living trust. The reason to do it is because Medicaid is only available to people who are below a certain total asset level. And if it's pretty low. And if you think that you might want to seek Medicaid to help pay for long-term care, then you would want to go talk to an estate planning attorney and have them walk you through the trust options. Even in that case, a trust is usually not the best option. So, with that said, reasons not to establish a living trust. They're pricey. They cost a lot of money to set up, both in legal fees and in work. You not only have to lay out all the specific terms about how things are going to flow and work together, who gets to say what about what, then you've got to transfer all your assets into it. And that means if you own property, you've got to deed that property over into the trust. If you've got bank accounts, all those bank accounts need to be retitled in the name of the trust. Any check you sign from those accounts, you're signing as a trustee of the trust, not as yourself. You don't own anything anymore. The trust does. So it can be a hassle to do all of this, transfer everything over into this separate legal entity that you've set up, this trust. And if you forget something, you'll still need a will. So in this case, it would be something we call a pour-over will, where anything that you forgot about or missed or that you acquired after you created the trust but didn't acquire in the name of the trust, all of that, you need a will to pour over into the trust so that it gets handled along with everything else. I would never counsel anybody to create a trust and then just skip the will part, because you never know what you're going to miss. You might buy a new car, you might, sell your current property and buy a new piece of property. Life changes and you don't want to miss anything. So the will is necessary. And if you need a will anyway, you might be better off with just a will. The other big reason not to do a trust that exists during your lifetime is taxes. So I printed this out today just to be sure. The tax rates, the income tax rates, I should say, for trusts are much higher than they are for individuals. If you've got property in a trust that earns income, then you're going to pay higher taxes on that property, most likely, than you would if you just owned it in your own name. And if you set up a trust and this property is owned in trust for another 15, 20 years, that can add up over time. If you've got brokerage accounts in a trust, same idea. The income you earn gets taxed at a higher rate than it would for just an individual. Before you go and talk to an estate planning attorney, it could be me, it could be any one of the other qualified attorneys in town who do this work. Here are some handy things to do ahead of time that make everything go a little bit more smoothly. If you already have estate planning documents, if you've already done a will, no matter how old it is, if you've got it, get it. Take it with you. If you've got a power of attorney, grab that, take it with you. If you have a healthcare proxy, a living will, any of the documents we've been talking about. If you have a trust that you've set up in your name, or a trust that you're a beneficiary of, maybe your parents created one, bring a copy. It's good to have a complete set of documents that the lawyer can look through and kind of give you the whole picture of what your options are based on those documents. Maybe nothing needs to be changed. In that case, it's a cheap visit. But it's good to have everything. Put together a summary of everything you own, including who owns it, who's actually named on it. And this includes, who owns your property, how they own it. Is it a joint tenancy with rights of survivorship, like we were talking about before? Who owns your bank accounts? Are they joint? Is someone named as a beneficiary on things? Who owns what? You want to pull together addresses, correct names, the contact information of the people that you're considering appointing to be agents under your power of attorney and your healthcare proxy. That's important information that goes into each one of these documents, and it's good to have that in that initial meeting so that we can just use it right then. We don't have to follow up. Yep. And kind of with that, think about who would be good to name in those roles. Who do you trust with your finances? Who would be a good power of attorney? Who do you trust to be decisive in the moment under a healthcare proxy? Who do you trust to carry out the instructions of your will? Who would be a good executor? Who would be a good backup for all those? Who would work together? Who wouldn't work together? Do you want them to act separately or independently? Think about your family and your close friends and loved ones who you might be considering for these roles, and have that in mind when you come to that meeting. Here's where you answer that question. Where do you store your original will? The critical term here is original. The only valid will is the original. You can make as many copies as you want. If you lose the original, you might as well not have a will. The original must be kept safe. That's the one that you submit to the court. It's got to be the original one that you put pen to paper to. We store, and this is beneficial for us and for our clients, we store original wills at our office for free in a locked room in fireproof file cabinets. I highly recommend doing that. A lot of people would prefer to have their original close to home, and that's perfectly fine too. Just keep it safe. You don't want to put it in a safe deposit box. I mean, when you think of the safest place to keep something like this, you might think safe deposit box. There's a reason you don't want to do that. If you die and the bank knows about it, and your safe deposit box is locked, but it also happens to contain the copy of the will, they're not going to let your executor open the safe deposit box without letters of appointment. They're called letters testamentary from the court. Testamentary. The only way your executor can get letters testamentary from the court is with the original will. So they're left in a bit of a bind. And it's this whole process they have to go through. It's a headache. Don't put your original will in a safe deposit box. So then what do you store in a safe deposit box? Valuables. So this can include documents, but not your will. Maybe stock certificates, things like that. But limit it to that as best you can. Don't put your will in there. You can name somebody as joint on your safe deposit box. And that oftentimes solves that problem of access. Don't make a person a deputy though, because as soon as you die, their access disappears. That's one designation you can have for somebody who's got access to your safe deposit box. You deputize them. But that is only good during your lifetime. That goes away when you die. We talked about this before. It's a good idea to check estate planning documents. Even if you've got them already and you think they're good, pull them out every 5, 7, 10 years just to make sure they still say what you want to say. That your life hasn't changed in ways that make you want to change the will. People get married, people get divorced, people pass away, people have kids. Kids who were 5 years old at the time you did your first will are now 45. Things change, and your will should be adapted to account for those changes. Remember, being an executor is not an honor. It's a challenge. The initial inclination is for people to want to treat their kids fairly and not favor anybody. Maybe the eldest child is in a position of authority, by default in the family, but maybe that child is a high-powered finance executive in New York City working 80 hours a week and doesn't have the time to do this. Maybe the child that you want would not be capable of doing this, would just be an emotional wreck. You want to think about all the variables that might affect the person who you appoint to be your executor. It might be a reason to name 2 executors to act at the same time so they can kind of play off each other, but that's only if you think they'll work together. You can structure this in a number of different ways. but think about it beforehand. Once you've got all this done, once you've got everything in place, keep records accessible for your executor. And this can take many different forms. You can prepare a memo that you kind of keep in an available place that you can update over time that's got, here's where my accounts are. Simple information. These are the cars I own. I have a safe deposit box at CFCU or whatever. But the essential information that you think your executor might want to know that might make things easier. And then once you've kind of got a good handle on what everything is, and it takes some time, put it down somewhere and make sure your executor will find it. You don't have to give it to them ahead of time, but you can, as long as you think they'll be able to get to it. The last point here. People like to think that there's going to be a big moment where everybody goes to the attorney and says, okay, this is the reading of the will, and everybody gasps when so-and-so doesn't get what they thought they were going to get. That's for the movies. That doesn't happen. You can instruct it in your will if you want to, but they don't necessarily have to do it.